Are you someone who's been injured because of someone else's fault? Do you think all you need to do is explain to the insurance company what happened and they'll just pay you? That's reasonable to believe, isn't it? No, that's wishful thinking. I have 5 tips to follow that answer these questions with a valuable bonus tip at the end. I've been a personal injury attorney for 30 years. My clients consistently give me and my staff 5-star reviews at the end of their PI cases because I give them the following 5 tips at the start of their PI cases. So here we go. Mistake number 1. Giving a recorded statement to the other person's insurance company. Insurance companies will reach out to you shortly after the accident and will ask you to give them a recorded statement of what happened. What's wrong with this, you ask? Everything is wrong with that. First of all, let me be very clear. You do not have to give a recorded statement. You will never be told that you have to give a recorded statement, but the insurance adjuster that contacts you will be as sweet as pie and will try to lull you into giving them one. But resist that impulse. Resist that impulse with all of your being. Insurance companies know you are most vulnerable and the most candid about what happened within the first 72 hours of being injured. Insurance companies are hoping that you say too much. They will ask leading questions like, you had an opportunity to avoid that crash, didn't you? You saw that puddle on the floor, didn't you? The dog owner told you their dog is anxious around people before you pet that dog, didn't she? How long were you on your cell phone before the collision? They want to see if they can get you to admit some fault, to try to reduce the amount they have to pay you. Sometimes people say too much and the insurance company will deny liability altogether. I've never seen a situation where the insurance company took a statement and paid more money for having taken that statement. It just doesn't happen. The goal for them is to pay less money every single time. I know, I get it. You weren't at fault, and you think that by being cooperative, that by being helpful, that the insurance company will see things your way. But they don't. By giving a recorded statement, it only benefits the insurance company. You've heard the phrase, you have the right to remain silent. You've heard that all your life. Well, that applies to when you've been arrested. It's also great advice. It's fabulous advice. It's the best advice you can be given when the insurance company comes calling and asks you to give a recorded statement. Be brave. Just say no. Mistake number 2. Not treating for an injury or stopping treatment. I call this the 24/7 rule. In order to have a good personal injury case from which you may be paid the full value of your claim, the following have to be true. You sought medical treatment within 24 hours of the injury. You were diagnosed and the noted injuries are attributed to the car collision or the slip and fall or the dog bite or whatever caused you to be injured because of the fault of somebody else. Upon being discharged from that initial examination, you're told to follow up with your primary care physician, your PCP, if you continue to be in pain. And you do follow up. You follow up within 7 days of the date of the first time you were seen by a medical professional. Your PCP examines you and recommends further treatment, such as physical therapy, or suggests that you see a specialist, and you're given a referral for that purpose. Then you do go. You go to physical therapy or you go to the specialist, and you follow all of the recommended courses of treatment until conclusion, and you're declared to be at a medical end. If you do all of that, you have done everything you possibly can to assure that you will receive fair value for the loss of your health and for your pain and suffering. If you don't seek medical attention within 24 hours, it isn't fatal to your claim. I want to be very clear about that. But the longer you wait, the more you are giving the insurance company an opportunity to say you were injured sometime after the encounter with their insured. I had a case where my client was broadsided by another car, clearly the other person's fault. My client was young and he said he felt fine at the scene, although that night he was very uncomfortable. He was breaking out in cold sweats and his fingers would go numb. 3 weeks later, he still hadn't been to the doctor. But then he developed a shooting pain going down his arm when he reached for a can of soup in his cabinet. He went to the emergency room that night and they diagnosed him with a broken neck. Yeah, he had emergency surgery right there on the spot, and he was on a halo for 6 months. A halo is a big circular metal halo-looking thing that's bolted into your skull and mounted to your shoulders so that you can't turn your neck. When I made the claim against the other person's insurance company, they took the position that he broke his neck reaching for a can of soup. True story. Certainly there's going to be those cases where you feel banged up, but not bad enough to go to the doctor right away. Well, that's understandable. But if you're still not feeling well after 3 days, you need to go see somebody. By following up with your PCP or perhaps seeing your PCP for the first time within 7 days of being injured, you're establishing that your injury is more probable than not related to the injury caused by somebody else. Never forget, the insurance company doesn't want to pay you. If they have to pay you, they want to pay you as little as possible. By establishing a short timeline from the onset of injury to treatment, you're taking the argument away from the insurance company that the injury you're being seen for is not related to the conduct of their insured. The most harmful mistake people make to their injury claim is not following through with the recommended course of treatment. For instance, if you're sent to physical therapy, if you're given 10 sessions to attend but you only attend 3, the insurance company is going to take the position that you weren't that hurt to begin with, and they'll lowball the claim. Now, there could be very good reasons why you only attended 3 PT sessions. Maybe it wasn't helping. Maybe it caused you to be in more pain. Maybe it conflicted with having to go to work or taking care of the kids. All of those are good reasons. But unless you tell your physical therapist these things, your medical record will just say you failed to show up and you were administratively discharged from their service. Insurance companies love this when they see it. Don't make the insurance companies happy. Your medical records are the driving force behind every personal injury claim. It's said that if it isn't in your medical records, it didn't happen. Go to all of your appointments. Mistake number 3, speaking too casually at medical appointments. You just heard me say how important medical records are in every personal injury case. Every case lives and dies based on what's in the medical records. Everything you say has the potential of being written down. So when a medical professional asks you how you're doing, you might feel compelled to say, "Fine, thanks. How are you?" But they might write that down. They might write down that the patient says he feels fine. You don't want that in your record if it's not actually the case. When it comes to pain, you want to speak in terms of the pain scale. 0 is no pain and 10 is the worst pain you've ever felt in your life. When asked how you're doing, say I'm a 7. I was a 10 when I woke up, now I'm an 8. My knees are 3, my shoulders are 6. Whatever the answer is, use the pain scale. There'll be no mistaking in the record how you feel when you're using the pain scale. Another thing people do, and they shouldn't, is using percentages about how they feel. Whether they say it spontaneously or in response to being asked that question. Saying you feel 80% better at your 3rd PT session when you have 7 more to go will devalue your case, maybe to a point where it has no value. Don't volunteer any information about how you feel your treatment is working. If your treating professional asks you to use a percentage about how you think you're progressing, just say, "Let's see how I am at the end of my treatment." Listen, you were given a set number of sessions to try to get better. Finish your treatment first and say how you're feeling then. When at appointments, keep the chit-chat down to a minimum and focus on getting better. That's the key takeaway there. Mistake number 4, not telling your treatment professional about all of the pain that you're feeling. Just like saying too much can be a problem, sometimes not saying enough can be a problem. I had a client who was in a rollover crash. He had a crushing foot injury, which required surgery and physical therapy. When she was all done treating, when she was declared to be at a medical end, she said her back had been hurting the whole time, but she didn't want to say anything because she didn't want to be a burden. The insurance company took the initial position that it was an unrelated injury and denied liability. But fortunately, she mentioned back pain when she was first at the emergency room and then again at her follow-up appointment within 7 days of her injury. No one is going to know how you feel unless you tell them. Use the pain scale. My foot's a 10, my back's a 10. Tell people if you have shooting pain going down your legs or your arms, or if you have numbness or tingling in your toes or your fingers. All signs of a disc injury. Let people know if you're emotional, that you cry all the time for no reason, or if you're light sensitive. All indications of a head injury. Remember, if it's not in the medical records, it doesn't exist. Mistake number 5. Posting about your injury on social media. We live in a real-time world where everything gets posted on social media. What we're eating for lunch, the funny thing that one of your kids said, perhaps an injury that just happened. Saying things on social media about your injury, or about the person who injured you, or acting in a way that is inconsistent with the injury you claim just happened could prove detrimental to the value of your case. I had a client who was viciously bitten by a dog. There was no denying her severe injuries. There was no denying the dog was aggressive. There was no denying her permanent scarring. She claimed that she was now terrified of dogs, that she couldn't be anywhere near a dog. She sought psychological counseling for post-traumatic stress disorder and said she suffered panic attacks and nightmares. All pretty much what you'd expect a dog bite victim to be feeling. Except when it came to making the claim and laying that all out for the insurance adjuster, he asked me to go to her Facebook page while we were both on the phone. And I did. And there it was, my client's Facebook profile picture. She was cheek to cheek with a Siberian Husky. And this wasn't an old picture, it was a new picture. Her credibility was shot. The value of that case was cut in half because of that photo. And it's not as if these clients aren't told to be careful about what they do or say when it comes to their injuries. They are, just like I'm telling you now. But it still happens. Your injury is no one's business other than your own and perhaps the immediate family members that live with you. Just focus on getting better and stay off social media. Please, please. Here's a bonus tip. Keep a daily record of how you're feeling. The insurance industry is a worldwide trillion-dollar for-profit business. They are in it to make money and to keep their money, not handing it out to you because you happen to be a nice guy. But injuries alone don't make for the entire evaluation process. Pain and suffering is a big value driver when it comes to assessing the value of a claim. But not everyone keeps good records of their pain and suffering and what they've missed out on while they are getting better. Well, keeping your own record of how you're feeling and what you're missing out on is as easy as keeping a calendar and using a red marker to note the pain number and another marker to show what your injury prevented you from doing. Visualization is a great way to show the adjuster or judge or jury the impact the injury had on you and your life and will increase the value of your claim. For instance, here's a calendar I put together. In this example, you can see every month of the day is checked off with a pain scale number and what he missed out on in given days. It looks like this guy missed out on going to the gym every Wednesday, Thursday, and Friday and missed playing golf every Saturday. He also canceled plans on Sunday, September 5th, and he missed being able to pick up his 2-year-old grandson on September 12th, which happens to be Grandparents' Day. Bad things happen to good people. Don't make a bad situation worse by not taking advantage of every opportunity you have to be given everything you're entitled to receive for an injury caused by somebody else. I'm Dave Buckley. I'm a personal injury attorney. I hope you never need me, but I'm here if you do. I'd be flattered if you left a comment or liked or tagged or shared this video or watched my other videos on YouTube. Or click the link below for my free ebook on personal injury.